are you? And where are you going? What do you want?
Hello and welcome to Trusts and Estates Weekly. I'm your host, Kevin Bemmel, and I'm here every Monday at 10 a.m. Pacific time. And if you're thinking, you look different, yes, I do look different. I got new glasses on Friday. They are now rimless. I don't look like Poindexter, for those of you who are old enough to remember who that character is. But in any event, we're kicking off a new week here, and I'm very happy to have as my guest Marc Harris, who is the CEO of a company called ProbateCash. So this is a new topic for Trust and Estates Weekly. If you've watched my friend Bill Gross's show, Probate Weekly, which I know sounds suspiciously like the title of my show, that's because with Bill's consent, I borrowed his title and changed it a little bit. But Marc has been a guest on Bill's show, I think a couple of times. And in talking to Bill, he said, you got to have Marc on your show. This is a very important topic, and it's something that people need to know about because it can really help people out. But also there's a way to handle what's sometimes called a probate advance in a way that makes sure that people are protected and not being taken advantage of by the bad actors. So Marc, first of all, thanks so much for coming on the show this morning.
Thanks for having me, Kevin. I appreciate it, and I did enjoy being on Bill's show, and I'm glad y'all are good friends. So we'll have hopefully a helpful conversation today.
Yeah, absolutely. So I want to start out by asking you a question that I mentioned when we were just chatting before we went live. I met someone on Saturday who's a trust administration lawyer, and I was asking her how she got into that, and kind of like I just sort of ended up here. She started out as an M&A lawyer, and I think it's interesting for viewers to under how did you end up starting ProbateCash. I mean, I imagine when you were 12 and growing up, I suspect you weren't thinking to yourself, I want to start a probate advance company when I grow up. So
I'm still waiting for the Boston Celtics to call me.
Okay,
that was the original dream when I was 12 in the driveway. Starting to come to terms that may not happen. So I went to law school, and after law school, I actually started working at companies that did factoring future cash flows.
Okay.
So as opposed to doing more traditional law right off the bat, I was suddenly in-house counsel, where we were in companies that were providing upfront liquidity to people in exchange for their future cash flows. So initially, it was lottery prize payment streams. So if people won the lottery, if you won the lottery in California or just about anywhere in the country, a real lottery, not $100 lottery, but a 7-figure lottery or so, you'd be paid in an annuity, and that was it. There was no choice, and most people never even knew that they won the lottery. They thought they were going to go get a check for $1 million, $2 million, whatever it was, when in fact they're going to be paid over 20, 25, 30 years and tax withholding. So that was a shock to a lot of lottery winners. And what we would do is provide them upfront cash against their future cash flows. Then it became structured settlement payment rights. I've been involved in that. And then any other kind of future cash flows that are going to be paid by an insurance company, a state commission, or in the probate case, and a personal representative of an estate. And what happened is through the natural course, I have a lot of friends who are attorneys, and they practice probate, family law, personal injury, all of it. And one of the common themes is their clients are calling them, asking, when is this case going to get settled? When is the probate going to end? When going to get my money? I need money to live on. I was counting on it. And there were no answers except for the court takes a long time. So we found a way to provide upfront cash against potential lawsuit claims and with probate against an inheritance.
Mm-hmm.
So they're non-recourse advances, but which means we make these advances, and you have a lot of lawyers watching this show. So we take all the risk, the inherent risk of a probate, which are claims, challenges to the will, anything like that. And if there is something that occurs in the natural progress or slow progress of the probate, that's a risk we take. And so if we can't get paid back, we have no recourse against anybody in those situations.
Right, right. So it's interesting when you mentioned factoring, that really sort of brought this all into alignment. So just Kevin, what I call Kevin 1.0, I had a real estate company here in Los Angeles, and I had a specialized appraisal practice, and I dealt with a lot of asset-based lenders and other lenders in the sort of non-traditional business lending area. And so while I never did any collateral reviews for any factors, I knew a number of people in the factoring business, because again, it's all part of the non-traditional business lending. So that makes a lot of sense. And also I want to highlight that point. So this idea of non-recourse. So I think this is a key aspect of what you do, because if I'm an heir and I take an advance against my inheritance, and then for some reason the amount of my inheritance either doesn't materialize or is short, it sounds like, you get what you get from the probate, but you can't come to me to collect a shortfall. Is that essentially what you're saying?
Correct. Absent fraud, of course, if you were to get paid your inheritance and just didn't want to pay us, or something of that nature, or made some misrepresentations to us, that would be a different story. But yes, otherwise we are taking that risk. And the other benefit that these are non-recourse advances as opposed to loans. So of course, a lot of the people who need upfront money from us against their inheritance don't have the necessary credit to obtain a loan from any traditional kind of lender. Mm-hmm. They wouldn't be able to pay back the loan with certain payment dates because they're waiting and counting on the inheritance to pay us back. Mm-hmm. So there are no payment dates, there's no interest rate tied to this, and no collateral. And so it's for folks who need money against their inheritance but couldn't get it any other way, or perhaps they could get it. Maybe they do have an okay credit, but they don't have the time. And our company can usually fund beneficiaries of estates within 24 hours.
Oh, that's very fast.
Sure. And yeah, because we're looking at basically a couple of things. Number one, just like any purchase of property or a car, whatever you're buying. Number one, are you indeed an heir to the estate? Right? Mm-hmm. Do you have what would be, in effect, title to the property or something like that? Are you really entitled to inheritance, either in a will that we're looking at or in the line of intestacy? So we check that box, check. And then two, what is it that we believe, or you believe and we believe with our underwriting, that you will be entitled to at the end of the day? So usually it's the sale of a piece of property. That's oftentimes the significant asset of the estate. And that's also why it takes a while for the estate to close. Not only is it the only asset of the estate, but nobody can sell it until letters are obtained in the probate court. Mm-hmm. And it takes time to sell property. So that's also part of it.
And in order to verify that status as an heir, do you require that a probate already be open? Or are you willing to, literally look at a will and in essence make your own determination as to the validity of that will and the status of an individual as an heir under that will?
Yeah, that's a good question. And that's I'll modify the answer a little bit to that question. But most of the time we are making advances in a situation where a probate case is already open. Okay. However, the will may not be admitted by that time. We may see a will, but it may not be officially admitted and will still actually make an advance. There are times also, and we have relationships with lawyers throughout the country, that a lawyer may have an estate they're representing, and they understand that there's a property there. They've talked to the beneficiaries. Somebody's going to be coming in and they're going to open up the probate, but they haven't opened it up yet. Mm-hmm. But based on the lawyer's representation, I'll maybe give a small advance to the beneficiary in anticipation of that probate being open. I'll get to the part of the process, but it really helps to have the probate case open because we file, and in fact, in California, we're required to, there's a California statute governing inheritance assignments, but we need to actually file the assignment of the inheritance with the probate court. So in California, it's required by statute. It's the probate code 11604.5. So 11604.5 is the probate code that governs inheritance assignments. In the states where there is not a statute, which are most of them, we still follow the spirit of the California statute, which has, as you can imagine, significant consumer safeguards. And so we follow that spirit and file assignments in the probate court. And we also do everything we can to talk to the estate attorneys. We want no surprises. So it certainly is much better if everybody knows that there's a beneficiary taking the assignment and what's going to be paid back.
So to really digress into the weeds here for a minute, I'm assuming then that there is no provision in the Uniform Probate Code, I think it's called, that addresses probate advances. Because I know, for example, there was a provision written into it now, I think it's maybe about 10 years ago, about digital assets that has since been adopted by, probably 30, 35 of the 50 states plus, the territories. So somehow this hasn't found its way into that, I guess, yet, huh?
Yeah, it'd be a lot easier for everybody if it were. California has a statute in the code. Utah just recently got one. And so otherwise, it's pretty much the Wild West in that sense that there is no statute. And that's a problem a lot of times because I don't want to really proceed unless I have the cooperation of the attorney who represents the estate. If I have an attorney who doesn't represent the estate and doesn't understand what we're doing and doesn't want to get involved, it's a problem for us. It's a problem for the beneficiary of the estate who needs the money. But I'm concerned that's going to lead into a messy situation, even when I'm filing the assignment. So in California, where there's the assignment, a lot of California probate attorneys are familiar with at least that there is an option for heirs to obtain advances against their inheritance. They may not love the business. They may not want beneficiaries to do it. But they may actually embrace our business because it takes the pressure off of all the phone calls they're getting from beneficiaries. Right. So we have, some in each group, but is what our message is to folks, to professionals especially, is you should know about us. You should at least know we exist. So when you are fielding those calls, your paralegal is fielding those calls, your personal representative is fielding those calls. I mean, people have real life issues and they need money. And while it may not be something that you would ever need to do as an attorney, probably you wouldn't need to do it. Therefore, you can't imagine someone taking an advance. There's a whole group of people who really need the services, and to be able to say, hey, call these folks up, and I'm an attorney. And so call them up and see if it works. See if it's something you want to do. And we're certainly a no pressure organization. This is either works for people or it doesn't. And there's not a lot of selling to try to engage somebody for our services if they don't need it. It's just it's not the kind of a business. It doesn't work unless the person needs it.
Okay. And you mentioned too that it could potentially be an intestate situation. So with a will, at least, presumably the person potentially taking the advance is named in the will. In an intestate situation, right, they're either an heir under the laws of the particular state in which the probate is going to occur or not, but that's not always, I think, crystal clear. So how do you deal with that situation in terms of doing your due diligence as to whether someone, from ProbateCash's perspective, qualifies, at least potentially as an heir to it?
Yeah, that is a tricky situation. And even when we think we've got it figured out, sometimes there's that sibling that appears from that nobody told us, or there's no will, so there's a race by a sibling to open up an estate and hope they're going to get all the money and not tell anybody about it. So
right.
When it's intestate, we really do want to have that conversation with the estate attorney. We are learning all the information, both from the potential beneficiary who wants the advance, the estate attorney, and seeing what has been found. We will want to see in those situations almost always that there is no will, that it's intestate, and here's the tree, the family tree that is usually filed to show who gets what. And so we're treading more cautiously. So our advantage, the other part, Kevin, that I'm going to discuss is that we do not normally purchase the entire inheritance of somebody. Mm-hmm. It's almost exclusively a portion of somebody's inheritance. Number one, it's just a risk factor. Number two, though, we also like to keep everybody engaged in the final result, even the beneficiaries. Mm-hmm. So even though they may not have any legal rights to the estate itself as a personal representative, but we find it best to have them excited for the final result where they're still going to be receiving an inheritance. Mm-hmm. As each step, our comfort level of providing a more significant advance depends on where we are in the probate case. So if the will has not been admitted, letters haven't been issued, we're probably going to give a much smaller advance of what would be the inheritance that our beneficiary would receive. The claims period is another step. We're going to still be cautious because claims can come in and wipe out the beneficiary's inheritance, which would in turn could wipe us out. In California, you've got Medicaid out there, Medi-Cal that can come in and knock us out, and they can come in anytime. Actually, they can come in after the claims period. So, very, very harsh lessons we've learned in this business.
Yes, yeah. So, I mean, in the sort of panoply of lending / advancing funds, this strikes me as being certainly on the much more risky end of the spectrum than if the safest thing is, I don't know, a home mortgage, right, or something like that, right, where you've got real estate as collateral, you can get an appraisal, you can get title insurance, all that kind of stuff, right? You're in a much more vulnerable, or not you per se, but ProbateCash is in a much more vulnerable position. It seems to me.
Yeah, and that goes with as the part that we don't require a credit check and we don't require collateral. We are at the mercy of the inheritance that the heir is eventually going to receive. And then the kicker of our business is, even if we do everything right, the personal representative, who is often a sibling or just another family member, has to pay us. Now in California, there's a court order, and presumably the personal representative will follow those instructions. Presumably they're still talking to their attorney who's been representing them throughout this ordeal, but not always. And so we have a staff, we have a bunch of underwriters here who are looking at the cases where beneficiaries won in advance. So we're underwriting the cases themselves and talking to estate attorneys. And then we have folks, after we make an advance, we are following the progress of the estate. And as we're following the progress of the estate, we know when the property is about to be sold, and when the petition for final distribution, we're checking to see if we're in it in California, or just kind of remind all the parties that we have this assignment here and to pay us. So you have to be on top of that. The risk are like nothing else I've really ever seen in the lottery business. When we made advances, structured settlement advances, we had court orders actually designating us as the new payee of the monies that we were buying each period.
Mm-hmm.
And then the person or entity responsible for making payment to us was a state lottery commission,
Right.
a AAA rated, AA rated insurance company. I mean, you weren't concerned about just not getting paid. It was very professional. In this business, you have that concern. So it's as I go home and my wife says, "How was work today?" I said, "Oh, great. We handed out $100,000 today in advances." She's like, "Wow, that's fantastic." I'm like, "Yeah, we'll see. Ask me that in 9 months to a year from now."
Right. How much of it comes back?
Right.
Yeah.
Remarkably easy to give money away.
Yeah. Yes. Yes. I imagine that in a way that is the easy part of the business, right? Yeah. So, and then I had a follow-up question I was going to ask you about that. Oh, yeah. So, given how risky your position is, you mentioned kind of at the beginning that. Actually, you know what? Let's take a break real quick, sponsor break, and I'll come back with that question.
All right.
When life brings unexpected changes, managing inherited property shouldn't add to your stress. Magnum Properties specializes in probate and trust real estate management. We handle the complexities while you focus on what matters most. From property maintenance to tenant relations, from legal compliance to maximizing value, we're your trusted partner through every step. Magnum Properties, Inc., turning property challenges into peace of mind. Call us today at 213-264-4396 or visit magnumprops.com. So this is Trust and Estates Weekly, and I'm your host, Kevin Bemmel. My guest is Marc Harris of ProbateCash, and we've been talking about the process whereby Marc's staff will determine whether a particular heir will qualify to receive an advance, and the sort of the risk inherent in that for his company. So, Marc, the follow-up question I have for you is, having mentioned a while back that you don't charge any interest for these advances because they are an advance, not a loan, but nonetheless, you've got to be getting a return on the advance somehow, right? So, how does that work, and how does the risk profile of a particular heir figure into how you determine, I guess, how much is advanced versus how much how much of the particular beneficiary's inheritance will then be paid over to you?
Sure. So we have a saying here that there's facts and circumstances for every transaction. It's pretty amazing. Every one of these is different. And so when we're talking about how much of an advance we can provide, willing to provide, and repayment terms. So we do charge fees for the advances as opposed to an interest rate, and the fees are hefty. And that's the fees the standard fees usually begin at 25% of the advance amount, and they can go all the way up to 100% of the advance amount depending upon when we're repaid. So it's common for it to be 25% each quarter, and then going up 25% each quarter from there with a cap at 100%. That's a common pricing structure. And then I will say this, though, when the more cooperation, because you indicated and I have too, that this is a risky kind of business without collateral and our customer base. So if I'm getting cooperation from the attorneys who represent the estate, and the more cooperation the lawyers are involved in the process, then I can adjust the fees to reflect the risk. I mean, the fees I just discussed truly reflect the kind of risk our business has. So if I'm in a situation where I know almost for certain, and I never look, by the way, for legal representations or warranties from estate attorneys. If I needed that as a requirement, I could shut my doors tomorrow. So I understand that, but I like to have at least the cooperation. So, I know who I'm dealing with, and I'm not just throwing money into a sewer. I like to see it get repaid. And if I'm having a productive conversations with the estate attorney and understand the beneficiaries, I'm happy to adjust our fees accordingly to help them out. And as I said, I'm an attorney. Most of my friends are lawyers. God help me. My wife's a lawyer, family law attorney. Really, God help me. And so
you're married for life.
Yeah, I'm married. Happily, right, honey? So, I really, want to stress that as an attorney, I'm looking to solve problems, and that's not just for the beneficiary, but for the lawyers. And I get it. Lawyers need to look good in front of their clients, in front of the beneficiaries. And our job is to also, once we do business with an estate, we often have repeat business from other estates who are represented by that counsel, because now that counsel knows about us. Mm-hmm. And that's just everybody on this call, I'm sure, does their networking, and that's how we do networking from existing customers and the law firms that represent them. So that's important, and as we get to know them better, we can adjust our fees accordingly to the situation in hand.
Okay, so just to sort of take an example, let's say someone gets an advance of $10,000. So if the advance is paid back in the first 3 months, you're going to receive $12,500. Is that
correct?
Typically on a typical bet, and so then it would go to 1,500, or 15,000. 1750. So okay, got it. Okay, right. So it is, obviously it is expensive money. So are you required to get paid back through the probate, or could the person receiving the advance, let's say that something happened and now they have the money available, they don't have to wait for the probate to close, but they could pay it off sooner, and that way avoid additional fees on the advance. Are you agnostic as to how you get paid back?
We just prefer to get paid back. These can be paid back anytime, and we encourage it. Part of this business is, I know how expensive these can be. And the beneficiaries, if they can, should strive to pay us back as soon as possible. There could be preliminary distributions through the estate to repay us, or other means. If they are able to get traditional financing later on, then they can pay us back anytime. So yeah, there's no prepayment, not a penalty, nothing at all to discourage repayment.
I mean, and one of the reasons I ask is, you mentioned that you could, in some cases, fund in as short as 24 hours. I could imagine there was a situation where somebody really needed the money quickly. This gave them access to that money, but then, over the next 60 days, they can take out an equity line on their house or whatever. And, so you've helped them solve a problem, but on the other hand, they don't want to, let that advance linger there when they have much less expensive ways of obtaining that money.
Yeah. Last month we had that exact case. We provided a $200,000 advance to a beneficiary who really needed short-term money immediately. Their issue was timing, not fees, rates, but because they did have good credit, they could obtain a loan. They just didn't have the time to obtain the loan. And so they paid us back, I think, in like 30 days, something like that. So they got that first stage.
So given, the cost of the fees, what do you see as being, let's say, good reasons for taking an advance, as opposed to, we'll say, maybe inappropriate reasons?
Sure. So there's a bucket full of inappropriate reasons. There's a smaller bucket full of appropriate reasons. Paying expenses on the estate property is a very common issue. To pay taxes, to pay renovations to get the property ready to sell. If you represent the estate, and you see a lot of people see cash buyers all over the place, which is good for them. That's another business. But if you're a beneficiary of an estate and the personal representative sells to a cash buyer instead of maybe putting $50,000 into the house and sell it for a fair market value, which could be double or triple that cost, then everybody benefits from that situation. And so we often make advances. So $25,000 to $50,000 of repairs can be made to the home. That's a very common reason. Then the second reason is a lot of our customers, and if you have probate attorneys and even trustees on this call, on this podcast, you know that a lot of the beneficiaries never heard of probate. What they know of probate is from watching a movie or television. So somebody passes away, you go into the lawyer's office and can't wait for the reading of the will so you can get your house, your car, maybe some cash out of the bank account, and everybody go their merry way. And so because that's their strong thought and belief, that's the way it works, they are counting on the inheritance. I don't think it's ghouly that they're doing that. It's practical. They think they're going to get their money and they need it for life necessities, to pay their own rent, to pay tuition for schools, whatever it may be. So there are a whole bunch of real reasons that are incredibly valid that they need to know are the options here. And then they can determine, well, all right, just how badly do they need the money versus our fees? And that's something that they should weigh. Where I would not use our money for is to go take the kids to Disneyland. I wouldn't take it to go see a Taylor Swift or fill in the blank concert. Because the money is really expensive. So that's why. So, and I think it's important to talk to your family about it or talk to an attorney about it. We always encourage all of our customers to obtain professional advice one way or the other. We also, before we will make an advance, we do a recorded phone call with our customer. And in that recorded call, where obviously they know they're being recorded, we explain again to them what's in the contract, how much money they're going to receive, and making sure they understand how much they have to repay us depending upon when they repay us. And that's all on a recorded call. We do everything in our power to make sure there is no confusion. As I said, we talk also to the probate attorney, and then we file the assignment of the inheritance into the court as well. In California, we ask for, and everywhere we ask, in California it's given, but we ask for special notice. So we get noticed on the pleadings as well and can follow along. And another benefit for estate attorneys and personal representatives, because we're following along on the case, now those beneficiaries, instead of calling your office, can often call us just for the status, not to get more money or anything like that, but just to see where things are going. And they're very frustrated. And again, because of my background, our folks never say delays are on the attorneys representing the estate or judges or anything else. That's just it's the probate being the probate. But the idea is just to solve problems, and money solves problems, and not to make anybody out to be the bad person here. Estate attorneys or really anyone. We're all familiar with probate cases and other kinds of legal actions. They take time, and that's if they're non-adversarial.
Right. Right. Yeah. So it sounds like the sort of the dividing line between appropriate and inappropriate, if we use those terms, is, sort of needs and wants. Needs being shelter, food, healthcare, those true needs, not the things we tell ourselves that we need, right? Those are in general, those are the areas where you genuinely are solving a problem for someone, keeping them in their residence, keeping them fed, those kinds of things, preventing God forbid, a serious health situation getting worse, things like that. Is that?
Sure. I think that's a really good way of putting it, the needs versus wants. Now, the needs versus wants for one person, a need to one person could be a want to us. I see a lot of times, well, I need to buy a car. Mm-hmm. And that's when we're saying, do you really need to buy a car? And if you live in California, where public transport is iffy, and in Florida it's a lot worse, but you need a car to get to work, and so you need a car to get your kids to school sometimes. So yeah, sometimes in this country especially, a car is a need, not a want.
Right.
So yeah, I think that's a very fair way of putting it.
Okay. And you mentioned the idea of taking an advance to fix up a property so it can be sold essentially on a retail basis as opposed to a wholesale basis. So do you work with executors, personal representatives, administrators of estates? In that case, it's really the estate who's taking the advance as opposed to a beneficiary who's taking an advance?
All the time, that's the purpose of the advance. So if we do need somebody under the statute, it's an advance to a beneficiary, and the personal representative is usually a beneficiary as well. So we will provide the advance to that beneficiary, and then it's often an expense to the estate that would be shared at the end of the day. So if it's a $50,000 repayment at the end of the day, and there's 5 beneficiaries, then each beneficiary's share would go down $10,000 as an expense to the estate.
Got it. Okay, so it's working its way through the beneficiaries no matter what the use is.
Right. I mean, it's going to be it's going to be a fee. It's just like a claim. Now, we're not actually a creditor of the estate. We do not file a claim. So want to be that's also part of it. We get paid back last, or the attorneys are getting paid, the personal representatives getting paid. Approved creditors are going to get paid, and then ProbateCash gets paid. So we're down the bottom of the pecking order, and so that is, I hate the phrase, that is what it is, but that is our business. Because we're not a creditor, we're just taking an assignment of that. We're kind of in the shoes of the beneficiaries when they get their inheritance.
Okay, that's what I was going to ask you. So you essentially have sort of equivalent standing to a beneficiary, as opposed to, for example, an unsecured creditor or.
Correct. So where I want to get involved, if the personal representative isn't selling a home or acting in a responsible way, then that could be a reason why that's why I want to talk to the attorney up front to know if that could be a possibility. Anything can happen, of course, once the probate is going on. But yeah, we'll sometimes even get involved and ask the court to force the sale or to remove the personal representative. The usual stuff that any beneficiary would do when things aren't moving.
Right. And well, that question went away. So when you're getting paid, how does that process work logistically? In other words, is the payment coming, directly from the administrator? Is it coming through the beneficiary? So then you're relying on the beneficiary to pay you. What are the mechanics of you getting repaid?
Yeah, so that is also a good question. That's important to us because, as you can imagine, we want to, at almost all costs, avoid the money going to the beneficiary and then having to remind the beneficiary that they need to write a check to us. That's not a good way to run a business at all.
Right.
So we're looking to get paid from the personal representative. The beneficiary, in the assignment of their inheritance that we're filing with the court, is directing the personal representative to pay us the money that we're owed before paying that beneficiary themselves. So usually the checks are coming from the estate, but then the estate will adjust what the heir is entitled to receive after we're repaid. So it's usually the checks are being written by the personal representative.
Okay, and so I as my viewers know, I essentially act as a personal representative and administrator, whatever. So what liability might I have, if any, if for whatever, let's say I ignore, the claim to pay you, and I go ahead and pay the money over to the beneficiary. Am I, for example, would you consider that a breach of my fiduciary duty, or how would ProbateCash respond to that situation?
Yeah, that's a fair question. I mean, in with the personal representative who has in California, where there is a statute and they're required to pay us pursuant to order, they would actually be in breach of the order. They'd be in contempt of that order by not paying us, just as if they forgot to pay a creditor at that point. So, I mean, if a creditor didn't get paid, even though they were supposed to under the order, and instead the money went to the beneficiaries and the creditor was left trying to scramble and call 3 different beneficiaries to get paid back, I think the creditor would make some noise about the personal representative having failed to exercise their fiduciary duty. And that we're in that same boat for as with getting the inheritance. I mean, they are answering to a court order to pay us at that time. So we're in the petition for final distribution. So it'll say ProbateCash is due. It'll reference John Smith took an assignment of $20,000, and the personal representative will pay ProbateCash $20,000 of John Smith's inheritance, and that is going to be going from the petition to a final distribution into the order for final distribution.
Got it. Okay, let's take another quick break, and we'll be back. Probate and Trust TV, your curated source for the most useful and insightful content on estate planning and trust and probate administration, featuring standout professionals like Bill Gross, Paul Brabelet, James Cunningham, and yours truly. Whether you're a lawyer, accountant, real estate professional, or working on your own succession plan, this channel helps you quickly find the clearest, most practical content YouTube has to offer. Subscribe now to Probate and Trust TV. Spend more time learning, less time searching. Okay, so we're back at Trust and Estates Weekly, and again, I'm your host, Kevin Bemmel. My guest is Marc Harris, the CEO of ProbateCash. We've been really doing a pretty deep dive into the probate advance business that Marc has. So we were just talking about the mechanics of how Marc gets repaid, what liability a personal representative might have if that representative fails to pay Marc. So, Marc, next question. How do you handle a situation where, at least when you first underwrote a particular advance, it looked reasonably, straightforward, and then, a creditor pops up, maybe the creditor didn't receive notification during the original claim period, right? So now they still have, at least here in California, I believe it's 30 days statutorily, right, to file a claim. And now all of a sudden you've got a highly leveraged or even an insolvent estate. So what happens, from ProbateCash's perspective if something like that happens?
Yeah, I mean, that becomes unfortunate, and we look at that, and that is in Godfather terms, that's the business we have chosen, and that happens. That is why our fees are what they are. Is not often predictable to see these claims, and we try to predict claims. We ask state attorneys if they anticipate any claims, but who has a crystal ball? You don't know exactly what is there. That's why there's a creditor's period, and that's why there's the 30-day period as well for creditors and vistas. So I mean, that's our business. If it if everything went great, that would be fine. But that's that would be optimal. But that's just not realistic. So we in that instance we look and we realize that we're not going to get repaid, and the beneficiary. I mean, some beneficiaries see that and say, "Wow, this is maybe expensive money, but what if?" Some beneficiaries who understand the risk of probate say, "Wow, maybe I'll take $20,000 just in case." If $20,000, I mean, we talk about needs versus wants, but in the in a world of non-recourse and who knows what's behind the next door in the probate case. To have $20,000 up front and then everybody gets wiped out because of a claim, nobody gets paid an inheritance. If you got the 20,000, you got the 20,000, and there's no recourse that we have against you.
So, okay, and so following up on that idea of non-recourse, and you mentioned, non-recourse unless there is a fraud perpetrated. So, um, what kind of follow-up investigation might you do to determine if, say, the beneficiary who took the advance perhaps knew that that creditor was lurking out there, didn't disclose it, or perhaps the personal representative knew that there was a potential, creditor out there that hadn't been notified, and now here you are, sitting, presumably sitting with an advance that's not going to be paid back.
Sure. Well, I'm trying to think in all the many advances we've made, whether a beneficiary knew of a creditor coming down the pipe. I don't think I've had that experience yet, although potentially beneficiaries who knew they were going to be challenged by another party for the inheritance, or they were supposed to share the inheritance, and they were trying to claim the inheritance as a sole beneficiary. Something of that nature can happen.
Mm-hmm.
As far as the personal representative knowing that there could be a claim, there is no liability there for the personal representative, because the personal representative doesn't often know that we're even making an advance to a beneficiary until after we have filed the assignment in court. Now and we're really talking, we want to talk to the estate attorney, not as much to the personal representative before we make the advance. Oh, and besides, the personal representative is represented by counsel anyway, so we want to go through counsel if we were going to have any conversations with the personal representative. So there is no liability there with the personal representative. And the personal representative, also, let me be clear, unless they're also the beneficiary who's taking an advance from us, they're not in contract privity with us. They're not breaching any reps and warranties or any contract that they have not entered into with us. So they do have the fiduciary duty to pay us, but that's like any other duties they have as personal representative that they're getting compensated for.
Gotcha. I mean, it's an interesting take that the personal representative has his own counsel. Sometimes beneficiaries will have their separate counsel as well. I would have thought that ProbateCash would look at itself as a principal, and so if they wanted to, be in contact with the PR, they would, they would go principal to principal in essence. So I'm sorry. Yeah, go ahead.
Yeah, I'm always, I like the lawyers to know what's going on, because I assume the personal representative is going to call the attorney and say, hey, what is this about? And I just, maybe if an attorney is not being responsive after a couple of calls or emails, that may happen. And I agree from that perspective. I agree that we are a principal to a principal. It's more of a preference and courtesy as a professional to a professional that I want to get the estate attorneys involved. I really, I wouldn't prefer it if somebody called my client, it's not even behind my back. It's not being sneaky. I just like to know what's going on with my cases, and right. Who wants to be surprised?
Well, I will say your perspective is refreshing, because with these kind of matters, and I do this for a living, but I would much rather people engage initially with my lawyer, because in probably 80% of situations, I'm going to confer with my lawyer to explore what legal ramifications there might be to a particular situation. And so this is just sort of taking care of that whole aspect up front before we, get down to the substance. So.
Yeah, I mean, we're not. There's no trickery involved here. We're providing a service of money in exchange for a repayment against an inheritance. We're really trying to uncover facts. We're doing due diligence, and personal representatives do have that information, but their lawyers have that information. And we even ask the beneficiaries when they do provide an application to us. It's not for loans or anything like that, but we have just an application that has the case number, the county, who the estate attorney is, so we can reach out. And we also have that beneficiary provide us with written authority that we can call the estate attorney, even though the beneficiary is not the client. Just to put everybody's mind at ease. I mean, the biggest issue, one of the biggest issues in any business, of course, but especially this, if you've never heard of a company that's making advances to a beneficiary against their inheritance, and you're a responsible lawyer in California or elsewhere in the country, that could be unsettling to wonder who's involved in this, in this pot here, what's going on. And people need our service, and they are helped by having the estate attorneys on board, at least understanding that this is a real business. They're going to be paid real money, and that way our customers can have an honest conversation with themselves, their family members, or their professionals about whether they want to take an advance. But they need to get at least to that step, and so to not involve everybody, especially the professionals, at least to know that what we're doing. It's just bad business to me.
Yeah, no, I absolutely agree with that. So we have just a few minutes left. I want to address, and this is always a little bit, I think, difficult, if you will. And I'm not asking you to, name any, names, but we all know in every business there are bad actors, right? Who don't take the approach, for example, that you take, that you're looking to solve problems. You're looking to make sure people are fully informed that, all applicable laws are not just adhered to, but that the spirit of the law, not just the letter of the law, is adhered to. What do beneficiaries, what do estate attorneys, even trust attorneys, what do they need to be on the lookout for when it comes to dealing with a company that's doing probate advances? I mean, of course, the first answer is just don't do business with anybody but ProbateCash, right? So that solves that problem, right? So I always give my guests a shameless plug because I know they won't.
The show speaks for itself.
So you want to avoid any problems, just, get in touch with Mark or one of his people at ProbateCash. But let's just say, for the sake of discussion, right? A lawyer feels that, look, I need to talk to at least 2, 3, probate advance companies. What do you recommend they be on the lookout for?
Sure. One is is a company representative contacting you as an attorney, or are you just learning about it for the first time from your beneficiary or third party? That could be a sign that a company is not upfront. There's that world that says, oh, if a professional knows that our fees are high, they're just going to tell the beneficiary not to do it, or they're not going to cooperate. Right? That needs to be done upfront. That's often the case, and we do plenty of business with beneficiaries where the estate attorneys, as I said, wouldn't do it themselves and may not even recommend it, but people need money. And that's a fair assessment. So I think having the relationship with the companies is really important. And also, once you get to know a company, once you get to know us, you'll feel better that we're not just doing things the right way, but we're real. I'm a real lawyer. As far as I know, I'm in good standing with the Florida bar. I'm pretty sure I looked that up. So, we have reputations that we're proud of. A second thing I would encourage lawyers and other even beneficiaries to do is I would look at Google reviews. Those actually are very helpful. The Yelps or Google reviews, wherever reviews, and see what people are saying. Because it takes time for people to sit down and put in writing that they receive good service or potentially bad service. But the reviews will be what the reviews are. But I actually take some pride in that. Our company takes pride in reviews, because that's really listening to other customers' experiences that they had and naming who our customers are, I think is important. The fact that I'm here sitting with you, which I appreciate, or I've been on with Bill Gross, or I have my own webinars, I think that's important. The fact that I acknowledge that these aren't for everybody, I'm not trying to shove any advances down anyone's throat. If they don't work, they don't work. If they do, they do. The fact that I'm trying to get everybody involved on the front end, I don't want any surprises. I've rarely ever had a truly bad experience when everyone has at least been on board on the front end, at least know what's going on the front end. It's surprises or, save it for birthdays.
Very good. Well, I think this has been a very illuminating discussion on this topic. And like I said, this is the first time I've dealt with this on my show. I really appreciate you coming on and talking about this, especially so candidly. I think it again, shameless plug, I suppose, but it speaks to your integrity and the integrity of your business, right? And in the end, that is 90% of good business is the integrity of the individuals. So
no, I appreciate that, and I think going back also, I would say what companies are you dealing with, and what kind of licenses do the principals of the company have? Do they have anything to lose? Because there's no requirement that you have to be a lawyer to run a business like this or have any kind of minimal amount of money to enter into this business. There's nothing like that. So, are you dealing with somebody who, besides being honest, do they have something to lose if they're not? That's to me actually very important. I mean, that's why you guys are paying. That's why the lawyers on your show are paying malpractice insurance, right? Is you're paying it because somebody I can retain you, and I know that if there's a problem or you're negligent or you mess up, I have the insurance behind you, not unlike a bond and the probate. So
right.
That's important as well. So those are a lot of common sense stuff. But when you don't know of a business or industry, that's when you're most nervous up front, and that's when I encourage people the most to reach out and to have those conversations.
Very good. Well, Mark, I want to thank you very much for coming on the show today. Again, it's been a very enlightening talk, and I think it will be a true benefit to my viewers, because there are those situations where people, they need money for various needs or emergencies even. And I can say as an administrator, rarely am I in a position where I can go, oh, okay, well, we'll do an early distribution or something like that. That's very, very rarely is that even a possibility to consider. And so you really fill that important gap. So thanks so much for being on the show today.
No, I appreciate. Can I also do a shameless plug with my email address?
Oh yeah, absolutely.
Okay, so if you want to get in touch with me, it's Marc, MARC, at ProbateCash.com. Marc at ProbateCash.com. And my phone number is 561-476-0018 is my direct office line. So
okay, and I'll put that information in the show notes. So anyone, if you didn't catch that, just go to the show notes for the episode on YouTube. You can go to our YouTube channel, which is you've seen the crawl below you, and Mark's contact information will be there. And I know he'll be more than happy to talk with you and answer any questions that you have, so that you can better understand what ProbateCash does and how it might be able to help you or help your clients. So I'm going to do a quick wrap up, Mark. I'll have you hold tight, and then we'll go offline. So thank you all very much for joining us. I know we've got our live viewers on today, so appreciate you joining us. I'm off for the next 2 days for the Jewish holiday, but on Thursday at 5 p.m. Pacific time is my show Jiggers' Place, and we'll have a cocktail and a schmooze as we head in toward the end of the week. So I hope you'll join me then. And then 1 week from today, actually, I think it's a holiday, but we'll be back either for an episode of Trust and Estates Weekly or for a holiday edition of the Way to Wow shows. So Mark, once again, thank you so much for joining me. All of you out there, thanks for watching. And signing off as I always do, Marie, darling, you are my